Good morning. I'm David Curtin. I heard a lull descending, so I think it's time we might make a move. Thank you all for coming out, and happy new financial year to the lot of you. Tabet and Get is the most important decision of the High Court affecting medical negligence in recent years. It was clearly headed for the High Court when the Court of Appeal in New South Wales held that the decisions of previous courts in the Court of Appeal of New South Wales and Victoria were plainly wrong, and it's said by some to be the end of loss of a chance in Australia. We'll find out today whether that's true or not. We're fortunate to have two eminently qualified speakers to present to you. Both Paul and Sharon are very busy junior counsel in this area, known to many of you and used by many of you. They both have medical qualifications. Paul has specialist qualifications as a psychiatrist, and he tries to affect the air of a psychiatrist, although he's not as mad as most practising psychiatrists. And Sharon, in addition to having nursing qualifications, has specialist paediatric qualifications and a PhD in neurogenetics. They have the advantage or the attribute of being very approachable. Solicitors who use them continue to use them. I work with both of them and find them both very helpful and approachable. And the presentation that they have for you this morning will no doubt leave you all better informed. Could I introduce both of them? The format will be that they will both present a slideshow. There'll be a break in the middle. You'll no doubt have questions. We'll have time for questions at the end of it, so I'd ask you to refrain from asking any questions until then. Please welcome Paul and Sharon.
Thank you, David, and good morning. Tabet and Get is, as David says, really a landmark in particularly causation in the common law in Australia. The format will be that I'm going to speak about the facts of the case, and I'm going to then give the state of the authority leading up to Get and Tabet regarding, very briefly, causation generally, but loss of a chance in particular. Paul will then talk about the international authority. We'll then have a break. Paul will talk about the decision as handed down by the High Court, and then I'm going to discuss the implications of the decision in practice. So looking at the facts in Tabet and Get, Rima Get was a 6-year-old girl in 1991, and she had, the court found ultimately, she'd had headaches for a period of about 2 years on and off, and she was admitted to the hospital after she'd had a bout of chickenpox. So on the background of the headache, then intercurrent chickenpox. And she was admitted to the hospital with the headache, nausea and vomiting, and the paediatrician who saw her, Morris Get, examined her and decided that she had either meningitis or encephalitis consequent to the chickenpox. So the thinking was going down the chickenpox route. Then after she had been in hospital for 2 days, she had an episode where at 11 a.m. on the 13th of January, and really hours are critical in this case, at 11 a.m. on 13 January, she was noted by the nursing staff to have unequal pupils, and also that the right pupil didn't react to light. Then 3 days after admission, on the 14th of January 1991, she had a seizure. It was a very brief seizure. It was really an episode of staring rather than a convulsive seizure. A CT scan was undertaken in consequence to Rima suffering that seizure, and she was found to have a brain tumour. So she had two coincidental pathologies. She had the brain tumour, which had been giving her the headaches, and on top of that, the overlay of the chickenpox, which had influenced the thinking of her treating paediatrician. After the diagnosis of the brain tumour, she went on to have resection of the tumour and radiotherapy, and clearly, as she's still alive at the time of trial, and indeed today, she was cured, if you like, of the brain tumour. But she had significant ongoing brain damage with really marked neurological deficits, so she needed 24-hour care, she needed lots of equipment and therapies. Trial in 2007, she was aged 22 years and obviously continued to have significant impairment. So the critical facts are, the allegation was the allegation of the delay in diagnosis of the brain tumour for that really a 24-hour period. So turning now to the authority regarding causation in Australia, and many in this room will be well familiar with these authorities. These are really the critical authorities: Chappell and Hart, Naxarkis, Gavalis and Singh, and Rufo and Hossing, and I'll speak about each of those. As everyone here knows, the but-for test of causation requires that the injury wouldn't have occurred if the negligence hadn't occurred. But it also has to be foreseeable, but really this is a very low threshold test and isn't considered to be all-encompassing or determinative of causation. So that was found in March and Stromare by Mason, the Chief Justice Mason, that really the but-for test, it's an entry test, if you like, a threshold test only. And on the balance of probabilities, the law has been that breach must be proven to have materially contributed to the injury. And that's actually a House of Lords case in Bonington Castings. And this question of what is a material contribution is what has clouded or has influenced the thinking of Australian courts really for a couple of decades. That is, what is a material contribution and how does that affect causation? One of the very influencing decisions was that of Gaudron, Her Honour Justice Gaudron, where she said in Chappell and Hart that a material contribution to an injury is an act or omission that increases the risk of the injury. This was the original statement that has developed into this thinking that if you have an act or omission that increases the risk of an injury, combined with that injury eventuating, then that's enough for causation. So that became the thinking really in Australia for many years, pretty much until the decision of the High Court was handed down here in Tabet and Get. So Justice McPhee, although he was in dissent on the decision in Chappell and Hart, he agreed with Justice Gaudron when he said, if a wrongful act or omission results in an increased risk of injury to the plaintiff and that risk eventuates, then the defendant's conduct has materially contributed to the injury that the plaintiff suffers. So even if there are other factors. So really, again, this crucial mixing, this putting together of, has the act increased the risk of it occurring? And the issue of how much does it have to increase the risk really wasn't addressed. If a plaintiff could show that the material risk of the injury has increased and it wasn't negligible, and that risk eventuated, then that was thought to be causative. Moving on then to Naxarkis and Western General Hospital. This principle that if you increase the risk of injury and the injury eventuates was really approved in Naxarkis and Western General Hospital, again with Justice Gaudron and also by Justice Callinan. Justice Gaudron said, and this has been a phrase oft repeated in many, many cases and again influenced the thinking of the legal profession, if a wrongful act or omission results in an increased risk of injury to the plaintiff and that risk eventuates, the defendant's conduct has materially contributed to the injury, and you'll see that's almost identical to the previous obiter in Chappell and Hart. If the defendant can show, it shifts the burden of proof. That is, if a plaintiff can show that conduct of the defendant has increased the risk of the injury and the injury eventuates, then the burden of proof is moved from the plaintiff to the defendant in this previous thinking, in that the defendant then has to show either that the conduct had no effect at all or that the injury was inevitable. An example might be, let's imagine a child has a vertebral artery dissection that is leaking of blood between the layers of the major arteries that run up the back of the neck to the brain. And it occurred for, that is, this bleeding leakage occurred for reasons unrelated to the conduct of the defendant. But let's say the defendant had put some play equipment in the school and the child suffers a fall and extends his neck, for example, and then suffers a worsening of that vertebral artery dissection with brain injury. If the defendant could show that it was inevitable, pretty much, that that child was going to have an extension of that bleeding into the artery of his neck and suffer that injury, then the defendant won't be held responsible. So the defendant has to go so far as to show that the injury was going to progress in any event, and such the conduct had no effect, or that it had no effect in any event. There then developed really quite a long line of sometimes contradictory decisions of courts around Australia, which really developed this theme of increased risk of injury plus injury equals causation. If the conduct has no effect, if the injury is going to occur anyway, then the defendant can use that as an absolute defence. And in the Western Australian Supreme Court, they held in Western Australia and Watson that if the contribution to the of the breach to the injury is shown not to be negligible, causation may be met. And this is how the language developed. Justice McPhee held in Hemville, and Walker, in the High Court, that if the breach materially contributed to the injury, it will be regarded as a cause, even despite other causes having a significantly higher role or greater role in the causation of the injury than did the defendant's conduct. And if the breach, now this is a critical decision, this is Seltsam and McGuinness in the New South Wales Court of Appeal, where Chief Justice Spiegelman held, if the breach causes an increase in risk that does not rise above the level of a possibility, then causation fails. And what comes into thinking here is, well, what's a possibility versus a possibility clearly is not a probability. That is, if causation is to be met to greater than 50%, that is 51% or more, that's probability. If it's less than 50%, then that's a possibility. But does possibility here mean 5% causative risk? Does it mean 45%? So it's the thinking, although the statement is clear, what's not clear is what is the determination of how high is a possibility. In Bendix Mintex and Barnes, Chief Justice Spiegelman really gave some obiter that was the harbinger of Tabet and Tabet, that is, that this was an undecided issue that needed to be addressed by the High Court, which is that there is a tension between the suggestion that increased risk is sufficient to satisfy causation, to contribute to a material contribution, but contrasting with authority which says that you have to have a probability and not a possibility. So you've got these two thoughts that are really quite contradictory. The first is material increase or material contribution, meaning increase in risk, which has been interpreted over the last couple of decades to mean really almost any increase in risk that's not insignificant or not negligible. So if you get risk, and I'm guessing you may wish to debate how much, but 10, 20% would be enough to get you some damages if you were a plaintiff, because it's not negligible. But that doesn't satisfy the long-held understanding in the law, which is that causation, and in fact all of the elements, have to be proven on the balance of probabilities in order to be met. So those two concepts are really in conflict and needed to be resolved. A seminal case is Gavalis and Singh here in the Victorian Court of Appeal. Mr Gavalis had he alleges that he had a 2-year delay in the diagnosis of his brain tumour. And the frequency with which brain tumour difficulties come up in these cases tells you that brain tumours must be difficult to diagnose and that there's often confusion or delay in diagnosis. For some reason it seems to be the diagnosis par excellence that leads to this sort of litigation. Dr Singh was treating Gavalis. The plaintiff initially succeeded at trial and he was awarded damages in the sum of $30,000. The plaintiff succeeded on the allegation that he lost the chance of a better outcome, better medical outcome, if he'd been diagnosed earlier. Mr Gavalis appealed because, particularly on the quantum of damages. In the Court of Appeal, they granted the appeal and then remitted the matter to the County Court for rehearing on damages. But during this determination, the court considered the issue of loss of a chance and supported the concept that a material increase in risk and the injury leads to causation being met. Rufo and Hosking is an appeal decision of the New South Wales Court of Appeal. Ms Rufo had a condition called systemic lupus erythematosus, which is an autoimmune disorder, basically where her body's own immune system is breaking down her own tissues. And the treatment for that is steroids, often high-dose steroids. And it's possible to prescribe a steroid-sparing medication that will mean that the patient can have less doses of steroids for the same clinical effect, because steroids have a whole range of side effects, from psychosis to diabetes to osteoporosis, weakening of the bones and fractures. She developed microfractures in her vertebral column, so she had spinal fractures. And her allegation at trial was that had Dr Hosking prescribed the steroid-sparing agents, then she would have had a lesser dose of steroids and she wouldn't have got the nasty side effect of having some microfractures in her spine. The evidence on causation at trial was that the failure to prescribe these steroid-sparing medications had an effect, but it wasn't possible to prescribe a percentage in terms of causation, but the evidence was it was certainly less than 50%, so clearly a loss of a chance case, where loss of a chance cases have entered the lexicon in law as meaning where causation can't be proved to 51% or more. So she fell into that category, and she was successful, and she succeeded on appeal also. And Justice of Appeal Hodgson and Santo found that a plaintiff may recover damages for the loss of a chance of a better medical outcome, even when the chance is a less than even chance. So Gavalis and Singh and Rufo and Hosking have really dominated the landscape for the last few years. This was 2004, but it's been, I'm happy to be corrected by anyone who's, probably most people who've been in the law longer than I have, but that's been the thinking certainly this decade, that plaintiffs can recover for loss of a chance where causation can't be met to 50%. An interesting case in the Court of Appeal, the Shire of Lacool and Waters, where Justice of Appeal Nettle, with whom Justice of Appeal Buchanan and Acting Justice of Appeal Hollingworth agreed, really threw a bit of a spanner in the works in regarding the thinking of loss of a chance, where causation's not met to 51% or more. And I apologise for the lengthy quotation there. You do have it in your handouts, but I think it's an interesting thing because really this is in 2005, so only a year after Rufo and Hosking, because there has been these mumblings of dissent with the loss of a chance doctrine really throughout the courts for some time. And Justice of Appeal Nettle made this comment: despite what is said in Chapel and Hart, it was necessary for the respondent in this case to prove causation on the balance of probabilities. So the Chapel and Hart reference is, of course, to Justice Gaudron saying that increase the risk, get the injury, causation's met. So he's specifically saying that despite that obiter dicta, it was necessary for the respondent to prove causation on the balance of probabilities. The law is that in order to succeed in an action for damages for personal injury, the plaintiff must establish on the balance of probabilities that their injuries were caused or materially contributed to by the defendant's default. A plaintiff does not ordinarily prove his or her case merely by showing it's possible that his or her injury was caused or contributed to by the defendant's fault. So Justice Nettle is saying possibility, meaning less than 51%, is not enough to meet causation. Generally speaking, he or she must demonstrate that it is more likely than not that the defendant's default caused or contributed to the injury. Is more likely than not, that's the key thing, Justice Nettles saying he doesn't agree with the loss of a chance doctrine, and this was in 2005. Another case, Justice of Appeal Chernov in Frieden in St Laurent said in 2007 a similar thing. It seems to me, however, that what Justice Gordon relevantly said in Naxarkis, which is the same principle, is generally opposite to the present case. I take her on it to have been saying no more than if the jury was satisfied that the defendant's wrongful conduct resulted in an increased risk of injury to the plaintiff and that risk occurred, ordinarily they were entitled, but not required, to infer from these circumstances that the wrongdoing materially contributed to the injury and was causative of it, unless the defendant persuaded them that the conduct had no effect at all or that it would have occurred in any event. So this is my reading of this, is that here's a Court of Appeal judge saying what was said about increasing risk, injury, meeting causation is that it's a general comment only and that it's open to the jury to find it, not necessarily that it must be found. So it's a, although not directly conflicting with the increased risk, injury, causation doctrine, it's putting a gloss or an understanding on it, which means that it doesn't really depart from the usual understanding that causation must be met to 50%. Roads and Traffic Authority, just 2 years ago, where in the High Court, where Justice Keifel said, and this is really the case, or obiter dicta that leads up to a clearer understanding that there was no High Court authority that could be relied upon in proving loss of a chance. She said, no decision of this court holds that there is that equivalence or some lessening of the requirement of proof. The present state of authorities does not accept the possibility of risk of injury as sufficient to prove causation. So effectively saying this is not settled in the High Court, there's been no authority on which can be relied upon. And when you look back at it, the authorities that are relied on being the obiter dicta of Justice Gordon in Chappell and Hart and Naxarkis, supported by the Court of Appeal decisions in Gavalis and Singh in Victoria and Rufo and Hosking in New South Wales, that really forms the sum total of the authority that supported loss of a chance, meaning that causation can be met to less than 51% and succeed. I'm going to hand over now to Paul, who's going to speak about Get into Debt.